Hello, lovely people. How are you today? I'm just hopefully going to get this camera to work. Let's see. Hopefully everything works here. Oops, there I am. And if I can get the background working on here so you don't have to stare at my horrible little room here. I'll blur it if I can. There we go. I'll put that there. Hope you're doing well. So yes, we have some things happening. Hello, Mama Kay. Hello, Anna. How are you? So I have, sorry, I haven't been around. School holidays have started today. One school I've got 2 weeks. Another school I've got 3 weeks. So, and I haven't been. I just cannot shake this cough, horrible cough and cold. Plus, my team's playing tonight, and we're going to lose. So I need the distraction. So thank you for being here with me. So 7M and their lawyers have actually responded. So let's just have a look back here as to what's gone on here. Hello, Ruth. How are you? So we had the judgment that occurred. Then we had, oh, that's supposed to be, okay, we'll go back here. So then we had some correspondence filed from Katie's side, where they wanted to get permission to file a motion, and there has now been an update to that. So this is the letter that they filed here. Okay. And motion for they wanted to get permission to file a motion for reconsideration. I'm just hopefully going to make this bigger and make myself smaller. If I can do that, make this bigger. Right. So they sent a letter and put forward their arguments. Defendant letter requesting reconsideration. Now, we have now had a response to that from Amber or 7m's lawyers. Plaintiff's response to defendant's motion for consideration. Judge Willis. How did they start theirs off? They started, Dear Judge Willis, and as opposed to Dear Honourable Judge Willis. Plaintiffs respectfully oppose defendant's June 25th, 2025 request for leave to file a motion for reconsideration of the court's June 23, 2025 order denying motion, in part their motion for summary judgment. Defendant failed to identify compelling circumstances under Minnesota General Practice 11511 that would warrant reconsideration. Instead, the defendant re-argues points already addressed and properly rejected by the court. So they're saying no clear legal error exists regarding defendant's statements. Defendant mischaracterizes the court order as failing to perform a legal determination. Hello, short order of opinion versus fact. In reality, the court explicitly conducted the required threshold analysis and correctly found that a jury could view defendant's social media posts, including their use of sexual trafficking, human trafficking, sex trafficking, cults, and forced labor, as implying verifiable factual assertions, rather than the more rhetorical hyperbole. As the court noted, context matters. The content, frequency, and tone of defendant's post in their totality would lead a reasonable jury to conclude that her statements went to opinion. Defendant's reliance on Gertz and Milkovich is misplaced. Both cases reaffirm that even expressions of opinion may be actionable if they imply the existence of undisclosed defamatory facts. Defendant's post presented as purported insider knowledge about alleged criminal behavior go well beyond loose commentary. The court rightly found that this issue is not suitable for dismissal as a matter of law. What do you think about that argument that they've just put forward? To the courts of actual malice, defendant again attempts to reweigh evidence and improperly substitute their own judgment for that of the court. Plaintiffs submitted more conclusionary denials. They provided evidence that Miss Paulson acted with reckless disregard for truth, including her refusal to verify claims, her use of inflammatory language in spite of contradictory public information, and her continued repetition of discredit. The court did not misapply New York Times Co. versus Sullivan. It properly found a genuine issue of material fact under Anderson versus Liberty Lobby Inc. that precludes summary judgment. The court was not required to find direct evidence of defendant's subjective state of mind at summary judgment. Circumstantial evidence of purposeful avoidance of truth and a pattern of defamatory targeting here suffices to create a tribal issue of actual malice. And then they put a colon. The issue is that the judge had to find reasons why she couldn't grant the summary judgment and reasons why it needed to go to court. The judge wasn't, why she couldn't dismiss it. And as we know, she did put all of those views. Actually, it seems to be very well. And the thing is, these paragraphs are very well written and succinct. So at the moment, boycott advocacy does not immunize tortious interference. Defendant misstates the scope of NAACP versus Claiborne Hardware Co., which involved peaceful political protest, not personal, targeted campaigns that include knowingly false and defamatory content. The First Amendment does not protect wrongful conduct cloaked in advocacy. The court correctly found that whether Ms. Paulson's interference with the plaintiff's business relationship was justified is a factual issue under Casbro versus Ricks, especially where the interference is tied to defamatory statements not subject to constitutional protection. Further, defendants misread Bose Corp versus Consumer Union, which deals with the appellant's court's role in reviewing First Amendment issues. Bose Corp versus Consumers Union of US Inc. It does not convert every non-disputable legal issue at the trial court level. The court probably balanced these doctrines and found that summary judgment was not appropriate on the plaintiff's tortious interference claims. Defendant or evidence justifying reconsideration. Minnesota General Prac 11511 sets a high bar for reconsideration, limited to compelling circumstances such as newly discovered evidence or clear legal error. None are present here. Defendants' arguments were raised, briefed, and rejected. Disagreement with the court's ruling is not a basis for reconsideration. Plaintiff respectfully requests that the court deny defendant's request to file a motion for reconsideration. The June 23, 25 order correctly applied the law, identified tribal issues for the jury. No compelling circumstances warrant revisiting that decision. Respectfully submitted, Amber Stavig. And she signed hers off, very truly yours, Jennifer Moore, as opposed to respectfully submitted. So what are your thoughts on those documents at the moment? So now I guess now we have to wait to see what the judge decides is right, whether it can go for reconsideration. As I said, you have a right to appeal. You do have a right to appeal any decision. That's a right that you have. But for me, I think it would be better for them to put their efforts into preparing for trial rather than fighting these issues. or trying to settle. Settlement's always the best. Mama Kay says she thinks that Jennifer was trying to throw stuff on against the wall to see whether it would stick. She's also back on TikTok now because apparently she's back on the gypsy train on TikTok. I'm told now she's blocked me on TikTok, believe it or not. So I'm very sad about that. Of course I am not. So, you know, I've got that. Oh, dear. Look, I still think that there is an issue that yeah. So this is from the Without a Crystal Ball Reddit. Thank you to the people that put this all together. So she's back on TikTok. It has come to my attention that the internet finally realizes that Gypsy Rose has been like the whole time. I've been saying this for a year. Glad to see some of you all finally believe us. Now someone please find me my moderator, Faith. Gypsy getting drunk and wasted immediately off parole is to be expected. She has untreated substance use disorder and Ken has a serious drinking problem. The only reason she was sober was because of parole. Just hold on tight. Drunken fights, cop calls, and the rest will happen within a couple of months. Being a mother won't keep her sober. She doesn't care about her child. Now, here's the thing. Is that statement opinion or is it fact? How do you interpret that? This is new for some of you, but Good Wives Net, and I told you all of this was the deviant and told Nicholas she would give him a daughter so he could her 13. Here's the transcript. We were telling the truth. So well, that's right. She was saying Chrissy was saying that Chrissy was her best friend. That's right. They were best friends, weren't they? That you shouldn't be talking about. And as I said, is it opinion or is it fact? This is what's getting her into trouble a lot because she disguises opinion fact. The other thing is she says the red wine drinker. That's right. Then we've got this. So thank you to Miss Balls for again the people. Oh no, this is Haiti. This is Haiti Joy. Sorry, Haiti Joy. Haiti or yeah. So it says, look who's jealous of Becca. It's insane. We don't want you. Stay gone. So apparently she was saying that Becca Scoop, she's posted that Rebecca Scoops was deregistered as a nurse and that she can't, she's got nothing, she's not credible. Well, see, that's the thing. What she says always comes up as fact. And that's the problem. And that's what's getting her into a lot. So let's see what Miss Balls has got here for us. Her videos have been on, oh yeah, Miss Balls asks a very valid question here. Miss Balls says, I was just thinking, if KJ claims she won any of the court documents, she loves public record and releasing other people's info. She thinks audio of a shins at a church isn't even involved. The audio will probably be thrown out. That's the thing. It's 7 church. So well, and the thing is, she can't claim she's a nurse either, but yeah, because she's got no medical knowledge. Oh no, she has medical. She does have musical knowledge because she's got a child with lots of issues, and she has nurses. That makes her an expert on all things medical, doesn't it? I just want to do a little bit of a segue at the moment because there's been a horrible issue in my town where I live in Melbourne, Victoria. It's a big story. Now, there are calls now for men to be banned from childcare, and that's up. But this man here has been charged with 70 offences against children. 1,200 plus children have to be tested against STDs and other stuff. He's been charged with 70 offences and was employed by 20 childcare centres. He also had chlamydia, gonorrhea, and syphilis. To have contaminated children's food with his own sample. He's currently in high security isolation, and he's one sicko. Now, there's also been another match for having kitty pictures. A doctor in one just got busted with video and pics also, yeah. Another man they've discovered also has been charged for having pictures of children, not related to the childcare industry, but know each other, I believe. So that's 2 people. It's pretty horrific. But I think one of the things we have to be really careful about is making decisions rashly or emotionally, because to say that men cannot work in childcare because they could be a predator is, in my opinion, is saying that all men are evil, and not all men are evil. Not all men in childcare are evil. I just don't know. So there's lots of stories coming out now. So they are talking about tightening the regulations on childcare. They are also talking about, I know they're talking about banning phones and putting in cameras. Former colleague of Joshua Brown says she raised concerns over unsupervised children. It will be costly. A former worker at a centre where Joshua Brown is accused, and remember, he's only accused, so technically will be proven guilty. Said she raised concern about children being unsupervised at the centre 3 years ago, claiming some even wandered into cupboards with no one noticing. The woman, who asked not to be identified, worked with Brown at the Creative Garden Early Learning Centre in Point Cook in 2022. In an email to the Victorian Department of Education, seen by the publication, the worker criticised the practices and procedures at the centre, saying supervision itself was lacking, and it wasn't uncommon for a child to wander into an empty room next door without anyone noticing, or for children to be playing in water in bathrooms. Also, one educator to be left alone outside with over 20 children during rest time. Unrelated to the police case against Brown, she said she was worried about the safety of the children at this service, as well as the staff who are not being supported very well. She said the worker said she witnessed many times when the room was left out of ratio or just on, despite the amount of children with additional needs who required supervision. I was worried about the safety of the children at this service, as well as the staff who were not being supported very well. I don't feel comfortable coming out in public about this, and I'll be contacting the right channels, but I feel it needs to be known. I did my placement at the centre the guy from the news was at for the longest time in 2022. At the time he was there, she wrote, "I feel sick." So this is him. The Victorian Department of Health has been contacted for comment, but said an active police investigation to them from commenting. GA is looking to former workers' claims. In response to the current police investigation with regards to Brown, the safety and well-being of every child in our care is our priority, and it is responsibility shared by every member of the G8 team and one that sits at the hub. We are appalled by what happened, what has occurred. He's facing 70 charges, including of a child producing CA material, recklessly contaminating goods. He hasn't entered a plea. They've raided. They found a lot of CA stuff, and apparently he's been accused of filming children as young as 5 months. So the fact he worked in 20 childcare centres should be ringing alarm bells. A new wave of parents have since been thrown whether their children have been exposed. Childcare providers have confirmed they're working with police. So it looks, I thought we had pretty tight regulation anyway, but it looks they're going to be tightening this. The phones at work, I think that's not too bad, but it's going to cost. And the other problem is that they're saying all of these are private providers. So here's the thing, when you have private anything, their main concern is about the dollar. So the fact that they've got kids or children unsupervised, or they're trying to get quotas, they want to be able to pay the also no more casual working in childcare. Yes, that would be another thing, permanency. But see, they would have to, well, then, you know, that's the thing. People have to work. So it's a very interesting predicament to be in there. So he may have wanted to work in as many as possible. Who knows? He's a monster. But as I said, I'm not really I don't know that we have to ban everybody. All males, I think, but because everybody's evil. But what do you think? What do you think? She's back on the gypsy train because, well, that's right. do you think that all men should be banned? Yeah, look, he'll be do you want... I think the problem has been around that this has been blown out into going to fix this is rampant. There's something wrong. I mean, the only other way they can do it is to make it so that people that one parent can stay home. So that's the thing. The only problem is he'll be in solitary confinement. No, I don't think men should be banned, but I think childcare has to change. Well, the way it operates, there are obviously some very there needs to be some changes. That's why I'm saying they've got to be careful not just to jump in and make these rash changes. Oh. In my opinion, they've just got to be very, very careful. It's kind of situation at the moment. Very emotions are everywhere. Mm-hmm. Yeah. But yeah, definitely very interesting. That's all I'll say. Okay. But versus security, yeah. My parents are doing they're celebrating their 50th wedding anniversary, and I just found out you can get the congratulatory messages from the Prime Minister and the Governor General. I just had to fill in all of that stuff to get that done. And also you can get them, you can download it. And also you can get stuff for the king as well. But for the government, for example, I had to upload my my birth certificate with their marriage date on it, so to prove that they're actually going to be married for 50 years. So I'm getting from the king as well. I figured I may as well, hey? No, it doesn't go that far. Oh. It's only 60th. Ooh. King only does 60th for the 60th. Wait for another 10 years. So anyway, it's all right. Yeah, I know, 50 years. And let me just tell you that means that so they were married the year before I was born. So there's my age. So we always so they're celebrating their wedding anniversary this year, and I'm 50 next year. There you go. The other thing about the Prime Minister and Governor General is that you've got to put on the form whether you're happy for the. Meghan Markle does messages for $2.50. Oh dear. They say that you may also get a letter from your state or federal member and or premier. So yeah. But you have to show proof that they've been married for 50 years. I wonder whether how unusual that is these days. That's what I want to know. I'm not going to be on for much longer because I heard out my team's losing. My football team, I've come on just to distracted. Probably getting flogged. Let's have a look. Oh yeah, they are. They're getting absolutely flogged. Dismal result. So yeah, but anyway. Oh, painful. And it's interesting that the king has said for 60 years. So I mean, that's very interesting. Because again, how many people make 60 years now? And will they have to lower that threshold at some point in time? Will you be able to sue for being married for 10 years? Because 10 years, if you've been married for 10 years these days. So anyway, yeah. So anyway, I just want to leave you all with that, with the letter. What do you think? I mean, it's going to be very interesting to see how this all plays out. Just let you know, I had another dosage of my medical trial this week, and I've been sick the last 2 days. But I've now lost 5.5 kilos, and I've lost about 3 or 4 centimeters off my waist. And it is slow because I suffer from a lot of nausea after I have each of the injections. The work with the dietitian has been trying to get some food that I can keep down and stabilizing my eating. But now that really got that stabilized, we are now going to be looking at increasing the exercise and a push along. It's looking good. You think KJ is going to court still? How she's going to avoid it? I mean, it's going to be court either way, like the motion, or there's going to be court for this. I've implied some of the stuff that her lawyers has implied that the judge doesn't know what they're talking about. So, and remember, sometimes both sides can use the same court case to argue a point at someone who gives the best debate. It's where your debating skills come into. But yeah, I just find it very, very interesting. But and Miss Balls makes a really good point, is that if she was so certain that she'd won, why didn't she show the court documents and say, here, this is what the judge said? The fact that she hasn't, to me, and this is my opinion, as you know, my opinion is that, if she showed it, people might not have believed her. So it's a very interesting predicament that she's got at the moment. Yeah. All right. Well, thank you for watching. I've kept this short, but as I said, I just need a distraction from my football team getting absolutely smashed at the moment, and Harrison's team is the one that's playing my team. And yeah, he's letting me know about it too. And so thank you. If you could hit like and subscribe, let a jury have a look and see what they think. Remember, the threshold is balance of probability. What would a normal reader interpret by that post? There have been times where I have questioned, is this opinion or is this fact? Because we're confidential. Yeah, I don't know. But because she's put a lot now, because she's mentioned stuff on social media, though, it may actually be a little bit harder for her to keep things quiet. Say we've got a protective order on something that she's discussed on social media, for example, and we haven't seen all the evidence filed because of that protective order, but yet the judge has seen it all. So the judge has made decisions that we've not seen, that she has seen. You've got to remember, keep that in mind as well. So yes, there's a lot of stuff. There's so much to this. So, all right. So based on that, thank you very much for watching. And I will catch you next time. Please hit like and subscribe, crew, and I'll catch you next time. Bye for now.